All rise. Vous vous levez. Please be seated. Veuillez vous asseoir.
Your Honours, before you proceed, if I may, having got the schedule now for the final representations, the government wishes to request to have an opportunity after the final representations of the victims to make a final representation submission as well for no longer than 5 minutes, so that we are able to also make further submissions as the victims are doing before Your Honours. Yes, that's our request, Your Honours. I understand there would be sufficient time to slot that in, if Your Honours are minded to do that.
Thank you, Counsel. Thank you, Counsel. We will give you the floor before victims will start make the final submissions.
My request, Your Honours, if I wasn't clear, was to make our submissions after the final representations of the victims, which will certainly respond to what the government has already said, to have an opportunity to respond to the victim submissions. If that is acceptable, to do it after each of their 10-minute slots for 5 minutes only.
Okay, the chamber has decided by majority that you will be speak after the victims.
I'm grateful, Your Honours. And that would then be before the prosecutor, of course, so immediately after the victims. I'm grateful.
Thank you, Counsel. Well, then the police chamber now invites the legal representative of victims group 1. Understand, Mr. Gaino?
Thank you very much, Mr. President.
10 minutes, please.
Thank you. I respond first to the government of Afghanistan submissions, and then I'll
excuse me for misunderstanding. We would like invite the prosecutor to respond to the submission of the Islamic Republic of Afghanistan and Amici Korea at this stage during the 15 minutes, and then we will ask, Mr. Gaino to take the floor. Mr.
Thank you.
Gagila, please.
Thank you so much, Your Honors. Mr. President, Your Honors, I'll be brief. I don't think I need to use the 15 minutes. In particular, some of the topics that we were going to address have been covered so eloquently by Professor Sheffer that we feel that basically we have really nothing meaningful to add, other than to note perhaps that whatever the divergence of positions may be, is very nuanced and very, very small, really. Your Honors, first, I'll address some of the arguments made by Mr. Dixon on behalf of the Islamic Republic of Afghanistan yesterday, and then briefly touch on some submissions advanced by the Jerusalem Institute of Justice and others, and the European Center for Law and Justice. First, Your Honors, we would like to make clear that the prosecution welcomes the engagement of the government of Afghanistan with the court and its willingness to develop a constructive partnership. And in this sense, Your Honors, the prosecution always stands ready to work with national authorities and to promote national efforts to ensure accountability, and has done this in many situations to date. So in this sense, the submissions made by the Afghanistan representatives yesterday can only be seen as a positive step. But Your Honors, this does not detract from the fact that the focus of this appeal is not, and could never be, what positive developments have taken place recently in Afghanistan as to accountability for war crimes or crimes against humanity. This is a corrective proceeding related to a confined issue, as I said at the beginning of our submissions on Wednesday, whether the pretrial chamber erred in its interpretation or application of the interest of justice criterion to the instant situation. The issue of complementarity under Article 53(1)(b) is not part of this appeal. Nor is the remedy sought by Mr. Dixon, which is for you to set aside the pretrial chamber decision and simply render your own first instance decision based on new information, one that you can provide. Your review is not a de novo review. But you shouldn't provide Mr. Dixon's alternative request either. That is, his request to remand the matter for the pretrial chamber, but not to authorize the investigation, but rather to make a new determination on interests of justice based on additional information to be provided by the government of Afghanistan. Your Honors, first, interests of justice and complementarity are different legal requirements under the statute, and they should not be conflated in a single, all-encompassing, undefined and blurry category, as Mr. Dixon proposes. This is not the logic of the Rome Statute. Second, Your Honors, while we welcome the developments that have been described by Mr. Dixon, so far we have heard nothing that would justify a fundamental change in our position or that of the pretrial chamber concerning the admissibility of the situation, much less warrant the extraordinary and extra statutory procedure proposed by Mr. Dixon. And Your Honors, this impression has been reinforced by the submissions made earlier today by the Afghan human rights organizations. Third, Your Honors, these proceedings have already lasted for too long. It is slightly over 2 years since we filed our Article 15 request with the first pretrial chamber. It is in the interest of judicial economy and fairness to all involved, starting with the victims, who, as it has been repeatedly said here, have already waited for long enough, that we get a final decision on that request. So, Your Honors, the proper avenue is for Your Honors to authorize the commencement of the investigation as soon as possible. And here we agree with Mr. Gaynor yesterday and with Professor Sheffer today. As a territorial state, Afghanistan will then receive the Article 18 notification, and within a month of receipt of that notification, it can notify the court that it is investigating or has investigated its nationals or others within its jurisdiction for the relevant crimes, as provided by Article 18, paragraph 2. Now, this will trigger the Article 18 process and afford Afghanistan all the rights and all the obligations that are contemplated in that provision. This will ensure, first, the provision of clear and tangible information showing the existence of concrete investigative steps, if this exists, related to Article 5 crimes, and not only submissions from the bar table concerning the existence of certain government structures or agencies. So this will allow, if this process happens, for an informed decision on complementarity. And second, it will also provide for adequate and meaningful victim participation, which, as we have confirmed in this hearing, will be invaluable in assisting the Office of the Prosecutor and the pretrial chamber in reaching the right conclusion. Now, this procedure, Your Honors, I note, seems perfectly in line with the undertakings of cooperation and participation that the Afghan representatives have made before you, both orally and in writing. And of course, Afghanistan can also choose to sit and wait until a case is brought by the prosecutor before the court and then challenge the admissibility of that case. So it has ample recourse under the statute as to what to do. I would like also to make the point, Your Honors, that opening an investigation into this situation, as noted by others, it does nothing to prevent the Afghan authorities from carrying out their own domestic proceedings. On the contrary, we welcome that. Judge Morrison suggested this in his question yesterday, and Professor Sheffer was very clear on this point today, earlier today in his presentations. Both our investigations and any investigations carried out by the Afghan authorities can proceed perfectly well, side by side, in relation to different incidents and different perpetrators. And if they happen to relate to the same incidents or the same perpetrators, then that can be resolved through the normal admissibility procedures. Nothing in the opening of an investigation at this court stands opposed to any good faith efforts by the Afghan authorities to ensure justice for the citizens. A couple of small points to finish this part of my response, Your Honors. First, a correction. The Office of the Prosecutor did conduct missions in Afghanistan during 2013, 2015, and 2016. Admittedly, it did not in 2017, 2018, and 2019, but that was a time in which the pretrial chamber was deliberating on our request. Second, Your Honors, while we recognize the challenges noted by the Afghan representatives in terms of security and access to the field, we know that sadly, this is a reality that occurs frequently in situations before the court. For instance, Your Honors, the security situation in Libya is very bad, and access to the field is very limited. However, this has not prevented the Office of the Prosecutor from investigating and continuing to investigate into the situation. And identical considerations, I note, apply to lack of cooperation, which is another sad reality of international criminal investigations. Frankly, Your Honors, it would certainly not be the first time that the Office of the Prosecutor has to investigate with without the cooperation of some of the states involved. Now, turning to the points made by the Jerusalem Institute of Justice and the European Center for Law and Justice, we have listened to those points very carefully. We reiterate, Your Honors, that the issue of exercise of jurisdiction over nationals of non-state parties is not part of this appeal. Your Honors, in its decision at paragraph 50, the pretrial chamber was very clear. It asserted that conduct allegedly occurring in full or in part in the territory of Afghanistan or other state parties fell under the court's jurisdiction, and I quote, irrespective of the nationality of the offender, end of quote. This finding is not under appeal, and accordingly is not before you. I don't really need to say anything else on this point, perhaps other than noting that these proceedings are not a forum to discuss the policy and legal choices made by the drafters of the Rome Statute when adopting Article 12, or the duties of state parties to cooperate with the court under Part 9. But second, Your Honors, the statute itself provides for mechanisms for states to avail themselves of if they consider it justified, such as challenges to the jurisdiction of the court or consultations procedure in Article 97 for Part 9 requests made by the court. So any intervention by Your Honors in relation to these matters now would not only be premature and outside the scope of this appeal, it would also be unnecessary. And in this sense, Your Honors, I think that there is a difference of view between the prosecution and Professor Sheffer we don't think you should embark in any of these matters. In this appeal, you should stay within the confines boundaries of the matters that have been brought before you. Your Honors, this concludes our brief response. Thank you so much.
Thank you, Mr. Gavina. And now I will ask Mr. Gainer, please proceed.
Thank you very much, Mr. President. We endorse the comments made by the Office of the Prosecutor. It is clear from the record that Afghanistan is both unable and unwilling genuinely to carry out investigation into the crimes at issue. In particular, Afghanistan has had every opportunity to bring proceedings against members of its own armed forces. There has been unjustified delay by the government in bringing those proceedings. This delay is inconsistent with an intent to bring those responsible to justice. Therefore, the test in Article 17.2b is satisfied. Now, turning to the question of unable, which is the test in 17.3, that test is also satisfied. And we can see that on the basis of paragraphs 24 to 29 and 52C of the government's written submissions of the 2nd of December alone. Those alone prove that 17.3 is satisfied. There has been a substantial collapse or unavailability of Afghanistan's national judicial system. Afghanistan is unable to obtain suspects or necessary evidence and testimony on much of its territory, that part held by the Taliban and associated groups. In respect of Afghanistan's ability to exercise jurisdiction over crimes allegedly committed by international forces, it is clear, as we've heard, that there are legal and political impediments to doing that, and it plainly has not tried in any way to exercise jurisdiction over crimes by international forces. Now, Mr. Dixon says that we shouldn't discourage the government of Afghanistan from taking out reforms to improve the administration of justice and the rule of law in Afghanistan, and nobody is discouraging that. But 17.3 is not a value judgment. 17.3 is a purely factual assessment. Even a state with the best will in the world to investigate and prosecute, which is carrying out reforms to its legal system, still falls under 17.3 if it has lost control of large parts of its territory. Afghanistan is precisely the kind of situation that 17.3 was designed to cover. So the conclusion is inescapable that Afghanistan situation fully satisfies the Article 17 requirements for admissibility. I want to turn now to the jurisdictional points raised by the European Centre for Law and Justice and the Jerusalem Institute and other parties. And nothing in their submissions prevents, as Mr. Guerlia said, Your Honours from ordering the commencement of the investigation immediately. Ordering an investigation to begin does not deprive Afghanistan or the United States of legal remedies before this court. Far from it. Afghanistan or the United States can challenge the admissibility of a case or the jurisdiction of the case under Article 19.2b. The procedure is open to non-parties. It is the proper forum to hear and determine arguments, such as status of forces agreements, between the United States and Afghanistan, Article 98 agreements, and it is the appropriate forum in which to bring full and informed submissions concerning proceedings that have taken place or are taking place or are about to take place in the military justice systems of the United States or Afghanistan. Now, in respect of the view that we all have to take a very pessimistic view of what the next United States administration what position it might take on the US, on the ICC, let's not forget that in Nicaragua versus the United States, a decision of the International Court of Justice of the 27th of June 1986, at paragraph 10, the court noted that the United States took the position that the court is, quote, without jurisdiction to entertain the dispute. The US went on to say that the United States, quote, intends not to participate in any further proceedings, unquote. Now, roll on a few years, and we have Hamdan against Rumsfeld, a well-known judgment of the United States Supreme Court. And in that judgment, the US Supreme Court quoted with approval the judgment of the International Court of Justice in Nicaragua versus the United States on the interpretation of Common Article 3 of the Geneva Conventions. Now, as for timing, Mr. Kern emphasised how important it was to clear jurisdictional issues early in the proceedings. And indeed, 19.5, in fact, requires a state that makes an Article 19.2b challenge to make it, quote, at the earliest opportunity, unquote. So that addresses the urgency point made by Mr. Kern in his very eloquent submissions. Now, if Afghanistan or the United States were to disagree with a jurisdiction or an admissibility decision of the pretrial chamber, they have an appeal as of right to the appeals chamber under Article 19.6 and the now famous Article 82.1a. There are other remedies available under the statute as well as that process. This was alluded to by Mr. Guerrilla. Issues relating to treaties between Afghanistan and the United States, Article 98 agreement, status of forces agreement, and so on, can be raised by Afghanistan in accordance with Article 93.3 or Article 97C. I'm grateful to a very helpful article by Your Honour Judge Prost on the operation of Part 9 of the statute, which will be useful to all parties. Now, Afghanistan can argue in accordance with those provisions that complying with a request is prohibited in Afghanistan on the basis of an existing fundamental legal principle of general application. Under 97C, it can argue that a request might require Afghanistan, quote, to breach a pre-existing treaty obligation undertaken with respect to, unquote, the United States or any other state. Now, where disclosure of information by Afghanistan is sought by the court, pursuant to a request for cooperation, and if that request raises a national security issue, Afghanistan can invoke the 93.4 procedure, Article 93.4 of the statute. This can be invoked by Afghanistan or any other party which is minded to cooperate with the court. It is intended to address the national security concerns of those parties. So in short, the statute already envisages the tenor of most of the arguments made by the European Centre and made by the Jerusalem Institute. It provides specific procedures in which those arguments can be fully made and determined, and very importantly, it provides the relevant state with an appeal as of right on jurisdictions, on decisions with respect to jurisdiction or admissibility. Your Honours, what is not an option, I respectfully suggest, is to keep the preliminary examination open. That would be totally unconscionable. The process of justice at this court must progress. This is reflected in the presumption in favour of investigation, which is set out in Articles 53.1, 15.3, and 15.4. Justice must proceed, not stagnate. The preliminary examination here took 11 years. The preliminary examination in Libya lasted less than a week. Frankly, Your Honours, it is impossible to understand how a preliminary examination into, for example, Taliban crimes against women and girls could have lasted more than 2 or 3 days. Just how long does it take a reasonable person to conclude, on the basis of reading a dozen reports from reliable sources, that the Taliban's treatment of Afghanistan's women and children, quote, provides a reasonable basis to believe that a crime within the jurisdiction of the court has been or is being committed, close quote. From the victim's perspective, it really is a matter of enormous concern that the preliminary examination has lasted so long. It's been clear for many years that Afghanistan was either unable or unwilling to investigate. The conclusion is, of course, strongly reinforced by the submissions of the government of Afghanistan of the 2nd of December. The court can't simply, as our American friends would put it, keep kicking the can down the road. Recommencing the preliminary examination simply isn't an option. We must move forward to the investigation phase. Admissibility and jurisdiction hearings can be heard in due course. I want to turn now to the danger of working on the territory of Afghanistan. Mr. Guerrilla has already made some excellent points about this. And also let's remember about how much investigation can take place without having access to the territory of the situation in question. We are nearly in 2020. Technological advances mean that investigations can be advanced very significantly without access to territory. Investigators have cyber investigative tools that were science fiction just 20 years ago. The Werfali case at this court is an excellent example of a case constructed largely on open source material. Dutch investigators working to determine the identity of those responsible for downing Malaysia Airlines flight MH17 have made enormous advances in determining the identity of the anti-aircraft missile brigade that fired the projectile. They did not have access to the territory where that brigade is stationed. The Office of the Prosecutor has access to many servers located in ICC states parties. The UNAMA continues to issue quarterly reports on civilian casualties in Afghanistan. Most importantly, all states parties, once the investigation is triggered, who have information of relevance to the crimes that have been committed in Afghanistan will be required to comply with requests for assistance from this court, but that only is triggered if an investigation is ordered. When your honours retire to consider your verdict in this appeal, you do so not only as judges of the ICC, but as judges who are part of Afghanistan's legal order. When you deliberate, I'm sure you will not allow threats aimed at undermining the rule of law to distract you from your duty as judges to remain scrupulously impartial. When you deliberate, I respectfully ask you to remember one group of Afghans in particular who come to you for justice. The surviving women and girls who suffered such horrific abuses at the hands of the Taliban, ISIS, and other entities. I ask your honours to remember one perhaps uncomfortable but inescapable truth. At the end of the day, the prospects of any genuine investigation in Afghanistan are very slim. If your honours do not bring justice to those women and girls, nobody will. Thank you very much.
Thank you, Mr. Gaino. And now I'd like also please representatives of FIDVA, Mrs. Gallagher. Please keep the 10 minutes time limit.
Thank you, Your Honours, and I will be under that time speaking on behalf of all three components of LRV2 right now. Just a few small points. First, going back to complementarity, which a number of us have already addressed on the merits in our discussions of Wednesday and Thursday. But yesterday, just in light of the opinion offered by the European Centre for Law and Justice, on behalf of the three organizations in LRV2, the Center for Constitutional Rights, NYU Global Justice Clinic, and Reprieve, which are all components of this group, we have been litigating in U.S. courts for more than the better part of 15 years to try and have some measure of justice and accountability. I believe Michael Ratner, the former president of the Center for Constitutional Rights, filed the first habeas corpus petition 18 years ago this month. Over the course of those many years, we have sought meetings with the Department of Justice through the Department of State to have criminal investigations open. We have filed civil lawsuits in the U.S. where we have faced obstruction under, again, unfortunately, 3 successive administrations. We have filed habeas corpus petitions, as I mentioned, which have been fought for those 18 years. Our universal jurisdiction cases have been obstructed by the United States. And so we too are here truly at a court of last resort. I would also just like to note that there's a distinction between non-cooperation, whether principled or misguided, and active obstruction, intimidation, and threats. Finally, we appreciate, on this first point, we appreciate and fully endorse the submissions this morning by Professor Hanagari on behalf of the former UN Special Rapporteurs with regards to the regime that has been set out for accountability and redress, particularly for torture. the second point, yesterday it was said, again by the European Center for Law and Justice, that sometimes, quote, that a country should not be immune from, quote, something not going as planned. Just to again emphasize, as we have through our written submissions, including our victims' representations, that our submission is that what our clients were subjected to, and indeed so many victims of the U.S. torture program, was planned, organized, and what they endured was indeed not a mistake, but rather the object and purpose of the U.S. torture program. So it is a widespread or systematic, carefully planned policy. The third point, as we are now in a different position than we were on Wednesday, we would just ask your honors to please take into account all four grounds that the victims in our briefs represented by LRV2 and LRV3 put forward. So our two submissions on the interests of justice, as well as our submissions on the scope and the nexus to the armed conflict. So to the extent that your honors move before ground one, which we think is the place where this appeal should end, into a review of the interests of justice factors that the pretrial chamber looked at, which we say that they inappropriately looked at some of the factors. Please take into account also nexus and scope. And lastly, on behalf of the victims that we represent and their families, we express our deep appreciation for the honor and privilege of appearing before you over the last 3 days. Thank you.
Thank you, Mr. Gallagher. Mr. Pietrzak, V3, you have also the opportunity to address the chamber for next 10 minutes, please.
Mr. President, Your Honours, firstly, because Ms. Hollander is limited in what she can say, she has asked me to make all of our statements today on behalf of our client, Mr. Abd al-Rahim al-Nashiri. Ms. Hollander has asked me to tell you that when she met him in Guantanamo, in prison, in 2008, over 11 years ago, he took her hand as he told her about the torture he endured. She understood that all he wanted, all he sought, is accountability for the perpetrators of the terrible crimes committed against him. This is his last chance, his last resort, if you will, for justice, accountability, vindication of his rights as a victim of terrible crimes through criminal proceedings. I would like to address certain statements made yesterday on behalf of the European Center for Law and Justice. Mr. J. Sekulow argued yesterday, and I quote, "The United States has a very comprehensive military justice system and very comprehensive criminal justice system. But Mr. al-Nashiri is facing the death penalty in a military commission created exclusively to prosecute him, designed for that purpose. It has few of the rights, guarantees he would be granted in either the military or civil criminal justice systems in the United States. That commission and the criminal justice system have denied Mr. al-Nashiri his basic fair trial rights now for almost 2 decades as of the moment of his abduction by US authorities. They have denied him any accountability for the perpetrators of torture and other crimes which he has suffered. In fact, the European Court of Human Rights, in the case against Poland, found that the forced and extra-legal transfer of Mr. al-Nashiri to the United States was in violation of his fair trial rights under Article 6 of the European Convention on Human Rights because of the failure of the military commission or the justice system in the United States to meet the standards, the fair trial standards established under the European Convention on Human Rights. Even though the European Court of Human Rights expressly ruled that Poland should demand diplomatic guarantees or assurances from the United States that Mr. al-Nashiri's fair trial rights would be respected after his extra-legal and forcible transfer to the United States, neither such assurances nor diplomatic guarantees have ever been provided by the United States. More importantly, the unfair and abusive military justice system to which Mr. al-Nashiri is subjected to today is targeted only against Mr. al-Nashiri as a defendant. It seeks only his accountability, per fas et nefas. However, these proceedings, the investigation for which the Office of the Prosecutor seeks authorization before this court, concern Mr. al-Nashiri not as a defendant, but as a victim of torture and other grievous crimes in the context of the situation in Afghanistan. I want to make it clear that the United States justice system as a whole, both civil and military, and in particular, this peculiar system of justice before the military commission, they have completely failed Mr. al-Nashiri in this respect. He does not even have access to the ordinary United States civil or military justice systems. No investigation or other proceedings have been initiated or allowed before the United States authorities to vindicate his rights and hold accountable those who are responsible for his torture. In fact, agents of the United States authorities have taken active steps to impede any effective investigation by destroying video recordings of the torture and of the interrogations of our client. Needless to say, these recordings could have constituted important evidence in any investigation regarding the crimes committed against Mr. al-Nashiri. We wholly support the arguments made by the former special rapporteurs in their amicus brief, and so clearly presented today by Professor Hannah Gary. The impugned decision is a violation of the rights of Mr. al-Nashiri under jus cogens and the standards set forth so clearly in Articles 13 and 14 of the Convention Against Torture. Mr. al-Nashiri has the right to an effective remedy, to an effective investigation, and to accountability for the perpetrators of crimes committed against him. We therefore urge the appeal court, the appeal chamber, not only to change the impugned decision, but to do so in such a way as to make it express, to make it very clear that the investigation must not be limited in scope, as suggested by the pretrial chamber's decision. I would reiterate that the justice which Mr. al-Nashiri is due via an effective investigation will not be accessible if this court does not authorize an investigation in such a way as to leave no doubt that the scope of authorization for an investigation does include victims of the transnational and transjurisdictional system of torture, incommunicado detention, and forcible transfer, euphemistically referred to as the system of extraordinary rendition and the enhanced interrogation techniques program. We ask that the appeal chamber change the decision of the pretrial chamber and authorize the investigation in a way that leaves no doubt that the grievous crimes committed against Mr. al-Nashiri, violating his very dignity, his humanity, do not fall outside the scope of the investigation. Failure to do so at this stage will leave Mr. al-Nashiri without justice, with no chance of an effective investigation, and will ultimately result in impunity. Thank you.
Thank you, Counsel. This concludes final presentations of victims. I will now invite the representatives of State of Afghanistan to make final submission. Mr. Dixon, your 10 minutes begins now.
Yes.
Please proceed.
Thank you, Your Honours. We have to recall where we are in this process. An investigation has not been authorised as yet. We can't jump ahead and start looking at Article 18 and Article 19. At this stage, the court has to be satisfied of all of the requirements, either before the pretrial chamber or at the appeals chamber level. We are in squarely the field of Article 15.4. And that requires the court to consider admissibility, whether or not the case in relation to all the information that has been provided to the court is being dealt with by the national jurisdiction or not. Now, if it is, there is no grey area, Your Honours. The court can't say, well, we're nevertheless going to authorise an investigation so that we can have two investigations going alongside each other. That's the point I was making yesterday. It's an either or at this stage. Later down the line, yes, when cases develop, it might change. But the statute doesn't allow the court to say that an investigation can be authorized when the national jurisdiction is dealing with the same information that has been provided in the prosecution's application to investigate. Now, that is a factual matter. I accept that entirely. And some of those facts have been presented before Your Honours, and there have been responses. We don't accept many of the responses that have been made that the Office of International Crimes is defunct. But those are matters, as I've said in our alternative submission, that we are asking, in the alternative, could be dealt with by the pre-trial chamber rightly at this stage if it was sent back there. There is no justification for rushing ahead if there is now a genuine dispute over this issue, we say. It should be determined now in the logical sequence of the statute's framework. This is not something blurry that we're making up. The statute requires, first of all, those elements to be satisfied, including admissibility. Then an investigation can be authorized by the ICC, taking all those factors into account. And of course, the state has rights later on, but we're not at that stage. And I urge Your Honours not to be lured into jumping ahead. We've got to look at where we are at this point. And the state is coming before you in good faith as a dedicated ICC state party, saying we are investigating all of the information that is before Your Honours, not just parts of it. We're not saying, oh, we'd like to look at low-level perpetrators. Could you please look at high-level perpetrators? Our obligation as a state party is to look at all perpetrators wherever the evidence leads. That's what we're required to do by international law. And that's what we are doing. The preamble doesn't say that the ICC will look at high level and states you look at low level. The requirement is that we look at all potential perpetrators. And that's what's happening. That's why I explained that the law has changed to allow command responsibility to be charged. In one of the cases that I mentioned in the Paktia area regarding the Afghan security forces, that's a case where they're looking at who did it, but also who was in charge. That's a case that's actively before the War Crimes Unit at the moment, not a defunct unit that's doing nothing. I accept, Your Honours, those are factual matters that may have to be delved into further and are not possible to be ventilated in full today. But I'll make that point to say that we come here not as a second-class citizen state saying, well, can we have the scraps and look at the low-level perpetrators? We come saying we as a state are looking at all potential perpetrators. And that's where we need assistance. We accept that that is a very, very, very difficult task to take on. But that's the one we are determined to take on and have started taking on. And the submission I was trying to make yesterday was that we think we are in a better position, certainly as good as the ICC, to do that, particularly where we have the support of the court to do that right now. And as I emphasized, that doesn't mean that the court then disappears into the background. For 4 reasons, the ICC is still centrally involved. And that's permitted in the structure and scheme of the statute. First of all, it will be made clear that the ICC, under its structure, is allowing the national jurisdiction to do this and providing that support. Then there's the possibility of positive complementarity. Those arrangements can be made directly with the prosecutor to assist, as has happened in many other situations, the country involved. Then there's also, Your Honours, the monitoring procedure. And I mentioned Article 18.2 because there is that 6-month procedure there that the drafters envisaged. Exactly the same could apply. There's nothing stopping positive complementarity from allowing a 6th month or whatever time period of monitoring. And then fourthly, there's always the potential for the prosecution to come back and apply if needed. So the ICC is very much in the picture, not investigating alongside, but supporting the national jurisdiction, and there as the safety net at all times. And what we are urging as the state is not for overreach here, where if the state is genuinely willing to take this on, for that to be interpreted as, well, maybe you can do some of it, but we will, as the ICC, take over the other part. And to run the two in tandem. That's not permitted at this stage, we say, under the statute, Your Honours. I also just wish to emphasize one other matter that arose from what the NGOs in Afghanistan were saying. No doubt the victims want the ICC to investigate this matter, and who wouldn't? But I think with respect, that misses the point. The real issue is, will anything, if they look at the track record, be done right now? That paralysis is what we say kills hope, where because of the delays, yes, people want it to happen, but is it happening? We are trying to fill that void as the national jurisdiction to make sure that these cases can be brought now. What we say is, if there are factual disputes, that Your Honours are minded to refer back to the pre-trial chamber. That is an alternative we're putting forward, and I've placed perhaps more emphasis on that in my further submissions today, because that would allow these issues to be ventilated, together with all the other issues in relation to the interests of justice as well. And a final one in relation to that is one which His Excellency the Ambassador raised in his address, and which I reinforced as well. Another matter that could be taken into account if the matter was remitted, that being the priorities of peace and security. It was highlighted very aptly by the NGOs that one of those mothers most awfully affected by the loss of her son in a bombing attack said that justice means a peace where no mother ever loses a child. So justice can mean peace and preventative measures to stop further war crimes happening. And that might well be a factor that has to be weighed into how far the national jurisdiction in the immediate term can take the matters. That's not to in any way undermine the priority that's being placed currently on national investigations. Those are two twin factors we say could certainly be reconsidered. And instead of taking a knee-jerk reaction of saying, well, we must correct what the pre-trial chamber has done and authorize immediately, what we are urging is, let's go through the proper steps in a logical fashion. Let's look at what the state is doing, hear all the submissions, and we're no worse off. In fact, we say we are far better off and far more advanced, because the signal will be sent that the ICC is committed, the national jurisdiction will be allowed to function, and at all times the ICC remains there if needed. Those are submissions in reply, Your Honours.
Thank you, Mr. Dixon. And now I give the floor to my learned colleagues to ask questions. And this is first, I invite Judge Ibanez, please.
Thank you, Mr. Presiding Judge. The question goes to Professor Scheffer, please. Given that the interests of victims are a factor that the prosecutor must take into account under Article 53(1)(c, when analyzing whether there is any reason to believe that an investigation would not serve interest of justice, is it a mandate that the drafters impose to take into account whether the personal interests of victims are affected in the same way that it considered under Article 68.3, please? I hope it's clear, the question.
Your Honors, Judge, I'm just looking at 68.3. This is what you referred to?
Yeah,
Is
yeah.
that correct? I just want to make sure I recall exactly the terms of it. Yes. My recollection is that Article 68 certainly...
Excuse me, Professor, please, micro on.
My mic is on, sir.
Oh, excuse me.
I'll try this one. Can you hear me now? Okay, sorry about that. I don't have a precise memory of how Article 68 links to Article 53 in how we were drafting, but I would say that Article 68's focus on the interests of victims certainly would have an impact on what we were considering in Article 53. And it may be that the phrase interest of victims migrated into Article 53 after we were focused on Article 68, because remember, the whole focus on victims in the drafting of the Rome Statute occurred most strongly in 1977 and 1998 after the French government introduced it as a prominent feature of our discussions. So in Article 53, it would have been natural in considering whether or not to proceed with an investigation to bring the interest of victims into that calculation once we had established the priority of victims elsewhere in the Rome Statute. I doubt, although my memory is not perfect on this, I doubt that Article 53's reference to interests of victims preceded our focus on the interests of victims elsewhere in the statute. It probably followed it, and then that phrase was inserted. But that's the best my memory serves me at this point.
And there is another question, almost in the same vein, please. Regarding the analysis, whether is any reason to believe that an investigation would not serve to the interest of justice, could you please tell us about, first, the discussions at the Rome conference regarding the factors of gravity of the crimes and the interest of victims? Second, whether the factors considered by pre-trial chamber, that is the time elapsed, the lack of cooperation, financial considerations, have any relevance? And third, what factors are taken into consideration in the situation of other tribunals that you helped to design, such as Tribunal for Rwanda or the former Yugoslavia or Cambodia?
Right. I'll try to be as succinct as possible on your first question regarding gravity and interests of victims. Certainly the issue of gravity had been with us for several years in the negotiations. And I don't know exactly when it was introduced into Article 53. I'd have to check. But it would be astonishing for it not to be a factor of consideration in launching an investigation. It was a fundamental building block of the drafting exercise, the issue of the gravity of the crimes, because it created a realistic paradigm for the International Criminal Court. We could not be dealing with minor commissions of crimes. It was only the crimes of greatest gravity that would be the focus of the attention of the court for pragmatic reasons, as well as, frankly, for reasons of law. In terms of your second point, if you can just remind me, your second point was your second question, Judge. Could you remind me? You asked 3 questions.
Sorry. The second question or the second part of the question was if those factors considered by the pretrial chamber in the impugned decision,
Oh,
such
yes.
as the time elapsed,
Yeah.
financial situations,
Sorry.
etc.,
Yeah.
are factors that should be taken into consideration
Right.
to resolve this issue? Thank you.
Those issues simply, in my recollection, were not a factor of the negotiations hardly at all. I mean, it was simply not a factor of discussion that we would sit there and speculate about how long this process would take. I think most of us were rather optimistic that once the court was created, there would be a fairly timely application of the resources of the court and of the investigation of crimes, such that those issues would not be prominent issues in the operation of the court. And that did influence a lot of the discussions about Part 9 on cooperation, but those discussions or those issues then got sort of funneled into very specific discussions about how you achieve cooperation with a state. What are the steps that you go through to achieve prosecution or cooperation, not let's speculate if there's non-cooperation for 8 or 10 years, what do we do then? That wasn't part of the negotiating scenario. It was rather, how do you get there as quickly as possible? And then I'm sorry, my mind is so focused. Judge, what was your third question?
I would rather ask you, early we heard that you have 2 suggestions or proposals to the bench. I'm curious, could you share it with us?
Yes,
now,
there were only 2 suggestions. One is a very mild one, and that is that it might benefit the public understanding of this entire situation, including the understanding of certain governments, if it were possible for the prosecutor to have a more publicly available statement as to why this is in the interest of justice to proceed with an investigation on Afghanistan. One can always read her pleadings and get a full picture of why it's important, but sometimes I think there needs to be sort of a more public expression by the prosecutor in a more, sort of targeted way, so that governments and the public can have a much better understanding of why this is so important and being pressed forward in chambers. My second suggestion is for the appeals chamber, which I do consider has unique moral authority here, to send a message, just dicta. We're just talking about dicta here, but to send a message to the Assembly of States parties and to the UN Security Council to address the financial problems of this court in terms of sufficient resources for the Office of the Prosecutor, as well as, frankly, the Office of the Defense and the Public Defender, to be able to address these requirements that are presented. The Afghanistan situation is a clear example of where resources are needed by this court to achieve its work far more efficiently and with sufficient staff in order to address these issues. And that also goes for the victims and their representatives. These are huge budgetary items, but the way in which the Assembly of States parties addresses their assessment issues, the way in which the UN Security Council completely avoids any responsibility for spurring UN funding for the work of referrals that it itself has launched under the statute. And as a drafter, we anticipated the Security Council would actually take steps to stimulate UN funding for Security Council referrals. That was very clear in the negotiations. No doubt about that. It can't be forced, but it's certainly the Security Council should be pressing for it. And I know the prosecutor makes that plea constantly, as well as the president of the court when they appear before the Security Council. So my suggestion is simply that in the decision on this case, there might be a suggestion that the financial issues are prominent in the administration of justice, and they cannot be ignored. Thank you.
Thank you. Thank you.
Thank you, Professor Schäfer, for your extensive answers and for your suggestions. I'm afraid that the next question is also going to you. Judge Cross, please proceed.
Professor Schäfer, I want to take advantage of your extensive knowledge of the negotiating history and receive your comments. On one point, your submissions on Article 15 were very clear, but on one question, I'd appreciate your input, and that is in relation to the proper interpretation of Article 15.4 and the criteria which the pretrial chamber should be considering. And I place the question in this fashion on presuming or assuming for the argument that there is a different interpretation to be given to the words reasonable basis to proceed with an investigation in Article 3 and in Article 4, particularly because of the existence of Rule 48. So if there is a different interpretation to be given to that term in paragraph 4, is there not an interpretation that there are only two criteria for the pretrial chamber to consider, which is reasonable basis to proceed in the literal sense, a factual basis for the investigation, not a fanciful investigation, which was a concern, and secondly, the jurisdiction question, but not the issue of admissibility, especially given the proximity in time of triggering an Article 18 process after the authorization of the investigation. I would appreciate your comments, especially in light of the drafting history.
Right. The drafting history behind Article 15 really should be viewed on a quite simple plane of analysis, reasonable basis to proceed. Now, that does not set forth any stipulated criteria for the decision of the pretrial chamber to actually authorize the initiation of an investigation. And I don't recall that we were sitting there establishing specific criteria in our own understanding of a reasonable basis. We brought from all of our national judicial systems our own particular understanding of what it means to be on a reasonable basis to proceed, which is a very commonsensical platform of analysis. And also a somewhat low threshold as well. We didn't put any qualifying words on reasonable basis or significantly reasonable or substantial reasons, etc. That's not what we established in Article 15. But in the rules discussion after Rome, that's why Rule 58 emerged in the discussion, was because there was needed some sort of framework of analysis that the pretrial chamber could work with. Now that frame of analysis, however, is one that is imposed upon the proprio motu prosecutor, not on the pretrial chamber. The pretrial chamber, I mean, technically could ignore Rule 48 in its evaluation of an Article 15.4 application. It could just ignore it. But the proprio motu prosecutor, of course, being professional, would nonetheless go through the steps of Rule 48, and then if the proprio motu prosecutor is seeking to launch an investigation, it would be responsible for her to, in her pleading before the pretrial chamber, bring the criteria of Rule 48 forward. Now, that's where I said technically that would be parts A and B, because that's the positive moving forward reason she's coming to the pretrial chamber to launch an investigation. Practically speaking, however, if I were a judge on the pretrial chamber, I would say, well, thank you very much. This is all very interesting. What was your thinking about Part C? Did you ever think about Part C? Was there anything in Part C that came into your evaluation of this matter? Because I want to know what the negative aspect of it, was there any negative aspect that was brought to your attention while you were achieving your decision on jurisdiction and admissibility? But that question doesn't have to be asked by the pretrial chamber, is my response.
Thank you.
Thank you very much. We will now invite the Counsel of the Office of the Prosecutor to make the final submissions. You have 10 minutes. Please, Mr. Gurlia.
Thank you, Your Honors. I think I'll be shorter than that. Your Honors, it is now incumbent upon us in the prosecution to bring these proceedings to a close. But if I may, I hope that many of our colleagues in this courtroom will find that these remarks reflect their own views as well, even if in part. We have been moved by many of the submissions brought before the Peace Chamber by victims who have been affected in different ways by the alleged crimes in the situation. We are profoundly grateful for their participation and look forward to working constructively with them in the future. We're also grateful to the various amici curia, both inside the courtroom and those who have made written submissions, for the learning and expertise. For our own part, we take this opportunity to fully acknowledge that the duration of the preliminary examination in this situation, perhaps unavoidably, was very lengthy. The reports of alleged crimes falling within this situation continue even today, almost daily. They shock the conscience. And if any reminder was needed as to why an investigation should be authorized, we submit that Your Honors have heard that reminder here this week. Based on her careful and independent analysis during the preliminary examination, the prosecutor was and remains resolved to open an investigation of these matters and to make her best effort to deliver justice to the victims and hold perpetrators to account, as her mandate requires. We know that this will be difficult and the road ahead may still be very long. But we will approach this task with all the resolution, independence, and diligence that we can muster, without fear or favor, as we must. It is in this context that we have been particularly concerned by the reasoning in the pretrial chamber's decision. The difficulties arising from the decision have been thoroughly addressed in the various written submissions and in the oral arguments that Your Honors heard this week, and we do not propose to revisit them again. On the basis of the arguments that we and other colleagues during the last 3 days had made before this chamber, we renew our request to Your Honors to reverse the decision in its entirety and authorize the commencement of the investigation, or, alternatively, to direct the pretrial chamber to do so without any further delay. We would also like to take this moment finally to underline again our appreciation for the government of Afghanistan's decision to engage with the court and to participate in these proceedings. Even if we disagree with their view that as a matter of law, any recent efforts to address the alleged crimes at the national level are relevant to these corrective appeal proceedings. We invite Afghanistan to continue this engagement, including by effectively using the procedural rights and opportunities that the statute affords to it, if it so wishes. And we stress that Afghanistan will always find a receptive partner in the prosecution in seeking to promote domestic accountability for international crimes. In concluding, therefore, I would like to borrow words from Counsel for Afghanistan. It is indeed past time to grasp the nettle and to unleash the potential of the court and the Rome Statute in this situation. But that means, in our submission, correcting the errors in the pretrial chamber's decision and promptly authorizing an investigation. That is the procedural framework which states have established for the prosecutor to carry her next phase of her work, not reopening Article 15 proceedings. Proceedings must move forward, not backwards, as it has been said. And it is in the framework of an investigation, Your Honors, that the prosecutor can and will engage seriously not only with interested states, but also, and above all, with the victims of alleged crimes. This concludes our submissions, Your Honors. We appreciate the Chamber's patience and attention. Thank you.
Thank you, Council. The schedule for the final day of the hearing is now closed. This is complete. The Peace Chamber has had the privilege of hearing oral submissions during the last 3 days from each of you, and which will serve to greatly assist our deliberation and eventual judgment on the novel and important issues that the prosecutor's appeal has sized the Chamber with. The Peace Chamber is grateful for your participation and for your very good cooperation throughout the hearing. The Chamber will issue its fully reasoned judgment in due course. I thank all the court's officers, interpreters, reporters, as well the technicians and security for assisting with today's proceedings. I thank all of you. The hearing is now closed.
All rise.